I now welcome in person and via video conference the Australian Automotive Dealer Association. I understand information on parliamentary privilege has been given to you and also in relation to the protection of witnesses and evidence. So I would now like to ask witnesses from the Australian Automotive Dealer Association to each in turn start their full names and the capacities in which you appear. Once we've done that, I will invite you to make some opening remarks. So we might start with those of you in the room, and then I will move to Mr. Savage, and we'll work out who else needs to introduce themselves. Go ahead, please.
James Vortman, Chief Executive Officer of the Australian Automotive Dealer Association.
Good morning, Mr. Vortman.
Morning.
And Mr. Savage. You can please speak now, Mr. Savage, just so we can get your name and your title on record.
Thank you, Senator. Brian Savage, Chief Operating Officer of AADA.
Thank you. And I will now invite Mr. Vortman to make an opening statement.
Thank you, Chair. The Australian Automotive Dealer Association appears before you today on behalf of all the franchise dealers across Australia, and we bring a very simple message. The regulations of relations between car manufacturers and car dealers in Australia is not fit for purpose. For many years, we have been carrying this message, proposing a specific set of regulations akin to those enjoyed by dealers in places like the United States and the European Union. Unfortunately, we failed to enact the level of change required before February 2020, when General Motors executives based in Detroit made the decision to prematurely cancel some 185 Holden dealer agreements. In Australia, General Motors found an environment in which they could easily pull up stumps without adequately compensating their Holden dealers that had represented them for so many years. The franchising code of conduct and its weak dispute resolution mechanisms were no match for the Detroit-based Fortune 500 company. When the dust settled, only a small number of Holden dealers are still pursuing their dispute, despite threats from GM that they will spend years in court at great expense. Meanwhile, GM has stated its intent to launch a new business in Australia, General Motors Special Vehicles. It's been described by some of our members as the largest phoenix in Australian history. Unfortunately, this issue goes beyond the actions of one brand, and it is appropriate that this inquiry has broadened its focus to look at all relationships between dealers and manufacturers. The relationship is characterised by a profound power imbalance. Not all manufacturers use the power imbalance to exploit their dealers. However, significant abuses occur far too regularly. The time to act is now, or there will be further abuses against Australian businesses. The ease with which manufacturers can terminate or non-renew their dealers in Australia is of great concern given the very large investments they are required to make. Security of tenure is increasingly tenuous, and there are manufacturers who have placed their dealers on agreements spanning as little as 1 year. This would never be allowed in the US or the EU, where terms are most often perpetual or a minimum of 5 years. The ability of manufacturers to terminate non-renew agreements or change their business models without providing sufficient compensation is also very concerning. There are a number of dealers who are currently engaged in legal actions against manufacturers on the issue of compensation. Sadly, this will be an incredibly time-consuming and expensive process, pitting those dealers against massive organisations which are well placed to drag out proceedings. And this brings us to possibly one of the biggest failures in the current regulations, the lack of an appropriate dispute resolution mechanism. Mediation under the franchising code seldom results in resolution of disputes, and manufacturers are only too happy to invite dealers to take their disputes to the courts, where an expensive long battle awaits. This industry, more than most, is in need of dispute resolution which is cost-effective, timely, and provides a determinative outcome. We believe compulsory binding arbitration should be introduced. This inquiry has heard a number of mistruths from some manufacturers and their representative organisations. They continue to deny the existence of a power imbalance despite the fact that it has been confirmed by various inquiries and government-commissioned reports. They will point to the fact that dealers are well-resourced and sophisticated businesses, and this is often true, but the power imbalance stems from the size of the manufacturers, all of which are multinational corporations which at the upper end turn over hundreds of billions of dollars annually and employ hundreds of thousands of people worldwide. You will hear from them that General Motors Holden was an unusual and unprecedented circumstances, and I quote from the FCAI submission, "There is no evidence of distributors terminating dealer agreements in substantive numbers at all." This is plainly false. Aside from General Motors, there is an estimated 30 to 40 Honda dealers which have been terminated this year. Only in recent weeks, I've seen a letter of termination to a dealer citing his failure to meet sales target during the months in which the global pandemic was at its worst. Another dealer has been issued with a non-renewal notice in a way which suggests the manufacturer is in clear contravention of the franchising code. And there are dozens of non-renewal notices that have been issued to dealers over the past few years. The net effect of these terminations and non-renewals has had a devastating effect on many regional areas where dealerships provide crucial jobs. There are well-documented examples of regional dealerships having to close down due to the actions of manufacturers, causing job losses in the vulnerable communities which need them the most. Many manufacturers have made the point that most dealers are multi-franchised, and this is simply not relevant to this inquiry. The fact that a dealer may have successfully negotiated an agreement with another brand is not an excuse for other franchisors to exploit and treat them unfairly. All dealers deserve to be treated and compensated fairly, regardless of how they have structured their business. We will hear talk at this inquiry about a new model some manufacturers are moving to called the agency model. It is a model very different to the current one, to the current franchise dealer model, and could have significant implications for commercial viability of dealers which do become agents. We do not dispute the right of manufacturers to change their distribution models, but when these fundamental changes are made to the business, it should be done in a fair manner. In particular, dealers deserve full transparency and should be notified with their maximum amount of notice, and they should receive adequate compensation. Unfortunately, the practices we are hearing about from some manufacturers are anything but fair. I received a very concerning piece of information overnight regarding Honda Australia's move to an agency model. I've already mentioned that Honda has this year terminated between 30 and 40 dealerships as part of its move to an agency model. You will hear from some of those terminated dealers today. However, I would like to bring a matter to this committee's attention which concerns those Honda dealers which have been offered to remain as agents in lieu of their current dealer agreements. These dealers are now being asked by Honda to sign a transition deed which governs the relationship of the parties leading up to the signing of the agency agreement. The transition deed contains comprehensive releases in favour of Honda Australia. Specifically, if a Honda dealer signs this deed and upon reviewing the agency agreement decides that it's not commercial interest to sign it, they will have lost the rights to take any legal action against Honda Australia. In simple terms, Honda is putting these dealers in an incredibly difficult position. They're being pressured to forego their legal rights before being privy to the details of a new distribution model which has never been rolled out in the Australian market. This is not how you treat a valued partner. This is the epitome of a power imbalance which clearly exists and is frankly exploitative treatment. Finally, I reiterate our assertion that not all manufacturers treat their dealers poorly, but the manufacturer body has to cease denying the existence of a power imbalance and the potential for the abuse under the current system. The fact of the matter is that new car dealers make significant investments and play an important role in an incredibly important industry. They are vulnerable to the decisions being made in boardrooms in Tokyo, Stuttgart, and Detroit. And this inquiry needs to ask the question, are we happy for executives from some of the world's largest corporations to treat these Australian-owned businesses unfairly, or do we need to enact the protections which exist in other industrialised countries and will level the playing field between dealers and manufacturers? And I'm happy to take questions at that.
Chair, could I just ask if Mr. Vortman might provide a copy of that for us? The Secretariat will copy it and give it to us.
I will, of course I will, yeah.
Can you do that now?
I can ask my staff in Canberra to email it through.
Thank you very much.
For not providing it in advance.
Thank you, that's very helpful.
Thank you. Senator O'Neill, would you like to begin questions?
I'd love to, thank you.
Thank you.
Thank you for your opening remarks, Mr. Vortman, and I will come back to them, and particularly to the final commentary around exploitative treatment. because I think that is really at the heart of the issues that need to be discussed today. And the question is whether the government will stand up for businesses right across Australia in the automobile trading sector or not. How many dealerships does the AADA actually represent, Mr. Vortman?
So we represent all of Australia's franchise new car dealerships. In total, that's around 3,135 dealerships located in every state and territory and almost every electorate in the nation.
And the distribution network in regional and rural Australia, do you have a breakdown of how many there are?
I don't have numbers specifically for how many dealerships in regional and rural areas, but it's a prolific employer in those areas. It's very well known that dealerships are sort of, the bedrock of those regional and rural communities. They are one of the sort of businesses that employ, sponsor footy teams, all more often than not a family-owned business which has been in the community for generations, and very much part of the fabric of regional Australia.
There are also sites of very significant opportunity for young people and people who need to retrain, who might have a passion for cars, whether that's in detailing and maintaining or whether it's the automotive or the other repair parts that need to happen with cars. The quality control that happens out of those regional and rural dealerships in terms of apprenticeship standards, I'm sure is part of the success of the actual structure as it exists. What are your thoughts about the impact of the loss of the network on the training capacity and the quality of training for regional and rural Australians?
Yeah, so dealerships, the great thing about new car dealerships is they offer so many career paths. Most people think of them as just a retailing operation. They're not. They go beyond retail. They also service and repair many cars. There are finance and insurance jobs. These are simply jobs that are very crucial in regional and rural areas. And the apprenticeships in particular in regional Australia have sort of given so many young people living in those areas their first job. It's enabled them to develop those skills bases and begin a very sort of fruitful career in the industry. So if we were to sort of take those businesses away from the regions, it would leave a recognisable gap.
Thank you, Mr. Vortman. How many people do your members actually employ?
Our members employ 55,815 employees nationwide, and we employ an additional 4,463 dealer apprentices.
Okay, so we're talking about 60,000 lives literally hanging in the balance depending on the government's response to this call from the sector to have the government stand up for Australian jobs and Australian car dealers. How much did car dealerships contribute in taxes last year, in the last financial year, to the government coffers, which all Australians benefit from?
So we do an annual exercise in terms of the industry's economic contribution. There's a tax contribution there of over $2 billion. But dealers also play an incredibly important role in collecting taxes. As you know, the federal taxes, the luxury car tax, the GST, and then also taxes at the state level, such as registration charges and stamp duties. So in total, we have, as I said, $2 billion of direct taxes, but then they also collect an additional, and unfortunately I don't have the numbers, but I think it's another $2 billion in terms of those duties and charges at both state and federal levels.
What would happen if the sector as we know it disappears under the pressure of weight from the overseas manufacturers and the model that exists just was dissolved? What would the tax revenue implications for Australia be? How do you believe that the money would then circulate, Mr. Vortman?
Look, difficult to say, but what I would say is, the overwhelming majority of dealerships in Australia are owned by local family businesses. Only a little more than sort of 15% of the firms here are listed, but they're also sort of Australian-owned, and they pay taxes in this country. If sort of we move to a more direct selling, which is what I think you're talking about, system, there'd have to be questions about whether, sort of manufacturers who, to be frank, are all offshore multinational organisations. I suppose we'd have to look at how they structure their arrangements, and I don't know if
We've seen with other multinational companies, Mr. Vortman, though, Australians very concerned that because they reside overseas and they have a lot of money, that they can set up tax structures that actually take a lot of Australians' dollars from their pockets, but don't return in some cases, any money to the Australian tax system, despite their use of Australian facilities. So I think that is a matter of concern to me as a member of this committee. Could I just ask you to explain for people who don't know much about the car industry, you represent the car dealers that you've just put that on the record. We're going to hear evidence from the Federal Chamber of Automotive Industries. Who are they? Are your members of that as well? How do they operate, and who do they represent?
No, so the Australian Automotive Dealer Association exclusively represents franchised new car dealers, and our members are all franchised to a major automotive manufacturer. The FCAI is the body that represents those manufacturers.
Okay.
Yeah.
So when we hear from the Federal Chamber of Automotive Industries, the fact that we no longer manufacture cars in Australia means they don't represent Australian businesses, they represent offshore businesses.
Yes, you would have to sort of double check that with them, but I understand the overwhelming, almost all passenger vehicles in Australia are now imported. So they'd be representing those distributors who are sort of subsidiaries of those major offshore car companies.
Okay, thank you for making that clear. The reason I wanted to get that on the record is that you indicated that in the submission to this committee, the FCAI are being disingenuous by saying that there is no power imbalance. And my question goes to the inherent power imbalance that you have articulated does exist. And that was also the evidence of our first witnesses from the US who sought legislative protection against that power imbalance, namely the National Automobile Dealers Association of America. What is the power imbalance that exists between car dealers and the manufacturers? And how does it relate particularly to the compensation that's paid for showrooms and resolving disputes?
It's a good question. So, yes, I mentioned in my opening statements that we've had a rather coordinated effort from the manufacturers and their representative bodies to try and send a message to this inquiry that there is no power imbalance. And it is patently false. The power imbalance has been confirmed by a number of inquiries and independent government reviews, most recently by the Parliamentary Joint Committee, which looked into franchising. The ACCC, in its market study into the automotive industry, raised concerns around the power imbalance, and even the government most recently, when the industry department looked at including a schedule to the franchising code, confirmed that there is a power imbalance. So, it's quite, concerning that the manufacturers continue to peddle this line that there is no power imbalance. And they do it on the basis that they say car dealers are sophisticated businesses that are multi-franchised, and that is true. And we don't shy away from the fact that we are sophisticated businesses. We are proud of the fact that we're sophisticated businesses. But the power imbalance stems from the size of the people we are franchised to, and that is the manufacturers. They are some of the world's biggest corporations. They're almost, if you're looking at the top sort of 10 selling manufacturers in Australia, they're almost all Fortune 100 companies. They're turning over hundreds of billions of dollars a year. They're employing, in some cases, more than 300,000 people globally. They have the resources to sort of, to match any firm in the world. And when you ask me how this power imbalance plays out, well, very similar to what the representatives from the AADA were describing earlier. They appoint dealers, provide them with contracts which are very much skewed in their favour. These contracts, dealer agreements, are provided on a take-it-or-leave-it basis. And even in the event that they breach those contracts, which are very much skewed in their favour, as we saw with General Motors, as we are seeing with Honda, they manage to use their power and use the sort of regulatory environment in Australia to make sure that they are not subject to adequate compensation that they should be paying to their franchisors.
Has your organisation asked the government to provide relief from that form of abuse?
The AADA for many years has identified this problem, and we've constantly made representations on the need for regulations which are fit for purpose. We don't believe the franchising code that we're currently regulated by and the recently included schedule are sufficient enough to rein in the abuses by some manufacturers. Not all manufacturers, but yes, we have constantly for a number of years made the point that the regulatory landscape needs to be overhauled. And,
often, this is quite a partisan comment, so I'll just prepare for a bit of response from my LNP colleagues on this committee. Often the perception is created by the government that they are the party of business. You are representing 3,135 businesses with 55,000 employees, 4,000 apprentices. You are are you telling this committee that despite all of that action and voice from all of those sophisticated businesses, the government has not responded to your requests, and even their most recent responses do not actually solve the problem that you've articulated?
Yes, we've sort of, for many years, we've been calling for a specific set of protections, and, we have worked with the government in recent times, and we've been very upfront with them. The government introduced a schedule to the franchising code on 1 June of this year, and we just don't believe that what was introduced will make any difference. It certainly wouldn't have changed the way in which General Motors withdrew from this market, and we fear that it'll do nothing to rein in future sort of instances of manufacturers abusing their power. So unfortunately, the regime we have in place at the moment is not fit for purpose, and we will continue to sort of advocate to any government that's in power that we need better regulations.
In terms of the evidence we heard from the US this morning, when they faced this situation, they petitioned their state governments to provide them with legislation. Is the type of legislation that Mr Koblenz and Ms Bailey offered as models this morning, is that the type of legislation that you want this government to deliver to your sector to make sure that you continue to exist, that you continue to provide jobs, and that you continue to have competition that benefits the Australian consumer?
Absolutely. There are some elements of the US legislation that we think is crucial. It's crucial to ensuring that some of these Australian businesses are protected from the abuses of manufacturers. I would say that, we're not even proposing to go as far as the US in some instances, We aren't suggesting prohibition on direct sales and some of the, the other regulations that they have in place there. But we are so far away in Australia from what they have in the United States that, there is daylight, and we need to move much closer to the models they have in the United States if we want to see a thriving industry over here.
I'm sure that as an advocate for business, you want to see a thriving industry. As a representative of the ordinary Australian people, I want to make sure that people get a car that they can afford and that competition remains in the market. What's the risk if the government continues along its line of like keeping you at a distance, not bringing in regulatory reform that you think is going to solve the problem? What's the cost to the Australian people if the government don't get this right and soon?
Well, look, I mean, I think there are risks. The consumers have been put at risk recently by the actions of some manufacturers. I'd argue that many of those Holden customers, would be arguing that would they have bought a vehicle in the last 2 years if they knew that this manufacturer would be leaving the country. There are 1.6 million of those owners across Australia. But to get back to your point around competition, the franchise model has served this country very well. We have the intra-brand competition that Mr. Koblenz was talking about in his earlier session. We think Australia is one of the most competitive markets in the world. The manufacturers will make the argument that if you regulate, that we'll potentially undermine that competition by having them withdraw. All I would say to this committee is, go and have a look at the earnings that these companies are making. They're doing very well out of the Australian market. They're making good money, and if the price of them if staying in this market at the expense of treating their dealers well is the price we have to pay, then so be it. But I think most of the good manufacturers in Australia treat their dealers well. Will be able to sort of comply with what is baseline regulations which we see in markets like the US.
Thank you. You've made a couple of recommendations to the committee. But specifically, you've noted the issue of compensation for changes when somebody like GM leaves, changes to business models and binding arbitration. I just invite you to make a couple of short remarks about those matters that are in your sub.
Yeah, so, we spoke about the agency model during the previous session, and it's a live issue in Australia at the moment. Honda, as we mentioned, is going through a process in which they are moving to agency, and we're starting to hear some very concerning elements from that, how that transition is playing out. Having said that, we've been very clear for many years that manufacturers have the right to structure their distribution models in any way they think is appropriate. But there is a very simple principle. When doing so, you should offer compensation to those dealers who've often worked for decades to bring that brand up to where it is today. I'll use Mercedes as an example, and they've sort of flagged that they're going to go to this model in 2022. And, at the end of the day, there's probably very little we can do to stop Mercedes making that decision. Many of the dealers are anxious about this decision, and I can see why they're anxious, because they've worked very hard to make it one of the most successful brands in Australia. They were one of the most profitable brands. A few years ago, they were the most profitable brand in Australia. If you look at customer satisfaction surveys, they're up there. They're always up there as some of the best performing. That has been the work of the dealerships that represent Mercedes, and it's been a very successful model. And now they're being told that it's going to be turned on its head, and they're going to be operating a very different model, which might not be commercially viable. So it's concerning, but if it can't be stopped, what we would say is that compensation should be paid. And it should be paid for all the years of service, for all the facilities that have been invested in, and it should include, things such as the lost profit, the lost opportunity of selling the established goodwill, because it's a very different business, and all those wind-up costs. So I think it's a very simple prospect, and in the absence of effective dispute resolution, which accounts for the power imbalance, all that will happen is dealers contesting these compensation claims are going to end up spending years in court at great expense. So that's where the binding arbitration sort of comes in, and we think that was an essential ingredient that was missing during the Holden dispute with General Motors, and we believe it's incredibly important as more manufacturers look at making these types of decisions.
Okay. I do have a number of questions that I'd like to ask specific to Mercedes-Benz and Honda, if time allows. But can I go to what's of interest? You said to at least 1.6 million Australians who've bought General Motors Holden cars. What has the Holden experience really done in terms of the effect on the car manufacturers' future operations? Why didn't they negotiate an initial offer? And can you give us an update on what's happened to the 182 Holden car dealers across Australia that Holden, no longer sell?
Yes, so General Motors made their announcement in February, and a few weeks after that they made a compensation offer to all of the dealers, and it was immediately clear to us, based on feedback from all of our members, that that compensation offer was inadequate. The pandemic then struck. Many businesses got afflicted by cash flow problems, but General Motors never changed their offer, and there was a dispute which went on for some time. General Motors managed to ignore directives from the ACCC for them to mediate in good faith, although they went through a mediation process. They then ignored Minister Michaelia Cash's request for them to engage in binding arbitration, and they set their dealers a deadline. And the reason so many of the 185 dealers signed compensation deals with Holden is that they tied the ability to continue to service their customers. They said you'll only be able to do that if you sign up to our compensation offer.
So this is the example of power operating. Yeah. Basically, you've got your whole, you've got your house on the line, you've got your business on the line, you've got all the jobs on the line. Because the government did not provide a mechanism for mandatory arbitration, General Motors were able to walk away and say, take it or leave it, essentially. That's what happened, wasn't it?
Yeah, I think if we did have an ability to go to binding arbitration, every one of those Holden dealers expressed, they said they would go and they would put themselves before that process. But it took General Motors all of 2 days to dismiss the minister's request. That's where we got to. So the overwhelming majority of those dealers, had no choice, they felt, but to accept the compensation offer. And there's no question that they have been financially disadvantaged due to how that all played out. There are now still a number of dealers, 8 dealers representing around 13 brands, who will be going through with this dispute, and we're hoping to see that progress as quickly as possible. But frankly, it'll probably take a while.
And cost a lot of money.
It will cost a lot of money. And the thing that I'm more concerned about is the precedent. Okay. The precedent that's been set, it's essentially a blueprint for other manufacturers who have watched this play out and said, oh, well, this is not a bad way.
So in ordinary speak, these companies have looked around and they're figuring out where they can sort of put pressure. And where companies are not protected, they're going to have a bit of a go. So General Motors came in, they thought Australian was right for the picking. They've said, okay, we're going to change our model. We're going to distribute ourselves. This is our offer, take it or leave it. The government didn't protect the businesses, and so that whole thing's gone. Everyone's gone, hey, General Motors got away with it in Australia, stacks on. So now we've got Honda in on the act, we've got Mercedes-Benz saying they're going to do it, and that's a very different situation to what we're seeing from the testimony of our American business owners who are saying, no, our legislators protected our businesses enough that we're able to still keep employing lots of Americans in their context and deliver a competitive price point purchase for the sale of cars. That's a very different situation to what we're seeing here. Is that an accurate representation of really what's going on?
Yeah, look, absolutely. I think in particular we're seeing other manufacturers now look at what's happened.
Yeah, there's blood in the water, Mr. Fortman.
That's right. Some of them, such as Honda, are sort of, at a similar sort of stage to what Holden were, in that they're having to terminate a large number of dealers, and they've learned some lessons from that process.
So the lesson is you can get away with it, so now you don't even need to offer anything. Is that kind of where Honda are?
Well, what I've heard overnight, and I think it's crucially important that this committee questions Honda if they do appear at this inquiry, is these transition deeds that I'm talking about, which essentially says, we want you to be an agent, and under the new model, we're not going to give you the details of how this agency arrangement will work, but please sign this transition agreement, which essentially says you cannot take us to court if you don't like the details of what the agency agreement looks
So
like.
basically, Honda are delivering a contract to their own Honda dealers that says, please exploit me, please, and we want you to sign up to that.
Yes, essentially that is, and it's not only them. We've seen other manufacturers since the Holden situation start inserting clauses into their dealer agreements which says, in the event of you being terminated, you have no rights to compensation.
Right, so these are
Patently
unfair contract terms that are now being inserted, and there is no protection unless the government legislates.
There's no protection under the unfair contract terms laws at the moment. The government's currently, only in recent weeks, said they're going to change definitions to allow more businesses to be protected by those terms. However, many dealers will be still excluded because the threshold, which takes into account the number of employees, will still be too low for many of those dealers.
If I can just ask one about the FCAI, who state that the impact of Holden's withdrawal, that you're making a big song and dance about nothing. Essentially, they say that you're not being truthful with the committee, and look, this isn't really a problem. Car dealerships sell more than one brand anyway. Get over it. This is just business. That's essentially the flavour, in my own words, of their submission. What's wrong about that, or are they right, Mr. Vortman?
Well, all I say is we started mentioning this power imbalance way before General Motors did what they did. When they did, we were even shocked by the scale of it. And there's no question there's never been a bigger termination of dealers in Australia. But to say that terminations do not happen is false. In 2017, 30 Holden dealers were terminated on one day. As we spoke about a number of times in this presentation, 30 to 40 Honda dealers have been terminated this year. There are constantly dealers calling me talking about non-renewal, which is now the preferred method of de facto termination. So everything is not all good and well as the FCAI says it is. It clearly isn't. I don't discount that there are good manufacturers out there, and we'll be hearing from some of them during the course of this inquiry, and I thank them for treating their dealers well. But this is not a happy family across the industry.
Okay. Thank you for that, Mr. Vortman. Can I go to an example that makes clear what the impact of failure to respond by legislative instrument to this from this government? And I want to talk about a dealer in Dubbo. Right, Dubbo is in my duty electorate of the seat of Parkes. It's represented by the very affable Mr Mark Coulton. It covers most of northwest of New South Wales, that seat. Dubbo is a big town. That's the core provider of lots of health services into the area. It's got an airport. It's a big town in central New South Wales. The dealer out there, Mr Michael Adams, who owned the Golden West Automotive dealership in Dubbo, was impacted by this decision. Are you aware of Mr Adams?
Yes, I have read the articles and I've spoken to him before.
So according to a newspaper article on the 15th of September this year, he states that due to the sudden withdrawal of General Motors in the Australian market and Honda changing their business model arbitrarily, he had to close his business and let go of 40 employees. Why couldn't Mr Adams use the compensation that General Motors and Honda offered to pivot to selling a different brand, as the FCAI indicated is an easy fix in this situation? Why would that not work?
Look, I'll talk in general terms. It's not as simple as when you lose a brand such as Holden or Honda that you just replace it with another one. The automotive industry is in a state of decline. We've had 30 or 31, I'm not sure, but we've had a sustained period of months, I think it's 30, in which sales have declined. And there frankly aren't too many brands looking to expand their footprint. So yes, there have been occasions where, one of our members have been fortunate enough to replace the Holden dealership with another brand, or they've been able to rearrange it. But it is just not that simple that you can, it's not like buying a new, sort of television or something. It's a complicated process, and a lot of the chips have to fall your way for you to just replace one brand with another.
If Mr. Adams, clearly, it's a big deal to close down your car dealership and sack 40 people. Why, if he has a dispute, why wouldn't he just go to court? I mean, a lot of people are saying, well, you can go to the courts. Why would people like Mr. Adams of Dubbo not take court action in the situation that he faced with General Motors and with Honda?
So every dealer, and I'll use the Holden dealers as an example. So if we think around 175 of those dealers chose not to go to court, every one of them will have their own reasons. Most of them will say, I can't afford to spend this money and dedicate all this time. Some of them, would like to just focus on other business opportunities.
So they just cut their losses and run because either they haven't got the time or they haven't got the money to invest.
That's a very good explanation. That's a very good description. Cutting their losses and running, rather than letting this weigh on them for 3, 4, 5 years in court at great expense, and sort of great trauma, I think there's just so much scepticism that they could get a quick and cost-effective result, that they just sort of accept their fate, unfortunately.
So for people in Dubbo, is it a situation now that they can just order their vehicles from General Motors out of Sydney or Melbourne or a major city, and that the agency model will mean they'll get their car basically delivered to them, and then that's it, they're on their own?
Yeah, I'm not certain what the consumers in Dubbo, what circumstances they'd face. But there certainly are question marks of what the future looks like for those Holden and Honda owners, and where they'd have to travel to get those cars. This is something that's been happening for a number of years. Regional dealerships have been closing in places like sort of Bunbury, in places like Kalgoorlie. There was a group that closed in Wangaratta. There are large risks here to those consumers because we're seeing those businesses close down.
If time permits, I'd like to come back to specific questions around Honda and Mercedes-Benz, as I indicated, but can I just go now to the draft voluntary principles that were constructed by...
Senator O'Neill, it would be good if you do that, and then we'll give, I think Senator McGrath has a question, and then you might be able to come back and finish those
I
other
might
ones.
just put my question in now, if that's okay.
Thanks, Chair.
Look, I notice your concerns about compulsory binding arbitration, and that the government's recently announced changes to the franchising code introduced voluntary binding arbitration. Are you aware of any legal limitations to making arbitration compulsory under the franchising code?
Yeah, we have. That's a good question, Senator. And we have heard sort of suggestions that there are constitutional limits on making arbitration compulsory under the franchising code. We look at other industry codes. They've managed to find a way to do it in the grocery code of conduct. The current media bargaining code of conduct that's underway, which is supposed to level the playing field between sort of news providers and Google and Facebook. There's an avenue for binding arbitration there. So I understand there might be technicalities in how we sort of find a way to make it happen. And if there are constitutional limits within the franchising code, we accept that. But we would think that there has been a way found in other codes, and there should be a way found. We can find a way to do it in our industry too.
Okay, thank you. Senator.
Thank you, Chair. If I can continue? Thank you. I think that's a really good sort of segue to the next piece of material that I want to discuss with you this morning, Mr. Vortman. And that is a set of draft principles for new car dealership agreements. The thing I'm hopeful about from this is that it's clear that the government know there's a problem, but your evidence shows so far that what they did in June showed they know the problem, but they didn't deliver the proper answer. So my questions go to an indication in this document that the government are hearing your articulation of a problem, but I want to find out if this is actually going to solve the problem that you've described. So the principles, there are 6 of them, to provide guidance to participants of issues that should be considered when embarking on the development of a new vehicle dealership agreement. Did the AADA have input into these 6 principles? And I do believe that you've been provided a copy.
I have.
Yep, thank you. Mr. Vortman, what's your view of that?
We did. We were involved in a process with the Department of Industry and other automotive industry associations, and we are very supportive of these principles as they are here. If I was to be overly critical, I might try and flesh out some of the detail in Principle 6, which goes to dispute resolution, and I'd like to be more specific on what sort of timely commercial settlement dispute resolution is. So the mechanism is a binding arbitration.
Which goes to the questions that Senator
Yes.
McGrath was asking you.
Yeah.
Yes.
So as the principles stand here, we are supportive of their content, but the most important thing is the application of these principles. And that's where we have a very strong view that we need to make these mandatory.
Okay.
There's a suggestion from the manufacturers that, well, I don't even know if they think these principles are necessary, but if they are, they'd be urging for them to be voluntary.
Okay.
Yeah.
So, given the government's current decision-making around support for your sector, or lack of support for your sector versus the OEMs, in a battle between the OEMs telling Minister Andrews to make this voluntary when all of the businesses across Australia are saying it needs to be compulsory, mandatory, who do you think's likely to win, Mr. Vortman? What would you be betting on at this point of time, given the government's current behaviour?
Well, look, we're still awaiting a decision from the government, and
I love hope.
I'm very, very hopeful that they will, and I hope this inquiry will sort of, help reach the conclusion that we need this to be mandatory.
I hope so too, because all of these businesses across the country are critical. Critical for ordinary Australians to access, to actually receive the service that they need, to buy in their local community, to get the training that they need, to have the jobs. And I'm very concerned, based on the evidence we've heard this morning, that those businesses are immediately under pressing threat unless the government makes these principles mandatory and creates a form of arbitration that they found for the food and groceries and also for the dairy industry.
I share your hope, Senator.
With what you know about Mercedes, Honda and General Motors so far, would these principles, if they remain voluntary, have helped in any way?
No.
In terms of the principles as they stand, I guess they've come out of that context of the things that need redress, right? These are answers to these are responses to problems. Where have these principles been shown to be wanting in recent times? So in terms of the General Motors, Honda, Mercedes situation, where have they why do we need these principles to be articulated and then made mandatory?
Yeah, so look, excellent question, and these principles come, sort of a direct result of some of the behaviours we've seen in the past 12 months, frankly. It started with General Motors and the sort of total sort of lack of any desire to provide their dealers with the compensation they deserved. It was something that was recognised by many in our industry, but also by government, and that's why attempts were made by the likes of the ACCC and the government to try and bring GM into line, but the powers weren't there, and that is why we need some sort of guide which informs manufacturers and gives dealers confidence for future sort of circumstances which may arise. And these are good principles, but again, they're only good if they are mandatory.
Okay. The minister responsible for the regulation of the car market industry I've mentioned is Minister Karen Andrews. I believe that she has put on the public record that these principles should be led by industry, which I'm trying to understand exactly what that means, but it seems to me that she still thinks that the government might not need to be involved in this. I just give you the opportunity to put on the record for all of the Australian automotive dealers and their staff, what does Minister Andrews have to do to make sure that the Australian car industry is actually maintained? What does she need to do now?
Well, I think what the Minister meant there by being industry-led is, she probably holds out hope that ourselves, together with the manufacturers, can come to her with acceptance that these need to be, we can agree on a way forward. And I'm still hopeful that we can get the manufacturers to agree that we need this to be mandatory. But unfortunately, I don't hold out much hope for that outcome. So I think what we need to do is we need, all sides of politics to have a look at the situation as it's played out in the automotive industry, and to decide whether or not they want to sort of enact the protections that are sort of available to dealers in other industrialised countries, and do so regardless of the protestations we're receiving from manufacturers, because without making these, in the absence of making these principles mandatory, we will see further instances of abuse from manufacturers, and we will see, sort of dealers and those businesses that have been built up for years in this market significantly disadvantaged.
So it's time to stand up for Australian business is the message. One of the things about power imbalance is people are often silenced. In the franchising inquiries that we've had, this committee and other committees have received huge wads of paper, clearly identified by being put on a different colour paper, that are confidential submissions.
Yeah.
When we receive significant numbers of confidential submissions, it usually is because the people who are writing to us are so afraid to go out publicly and put on the record what's happening because the stakes are so high for them. So I'm thinking of, in the general franchising inquiry, businesses, in debt for $700,000 with our whole family house on the line, and losing, the threat of losing everything means that they are silenced and they're unable to put things forward. Because of parliamentary privilege, though, they can provide us with confidential documentation that gives us a sense of what's going on. We've received a lot of confidential submissions in this sector. So even though the businesses are sophisticated, they are running scared because of the power imbalance that's been part of our conversation today. In the case of Mercedes-Benz, do you believe that dealers are afraid of speaking out against Mercedes-Benz because it would affect their business negatively if they do so?
Yes, and look, I wouldn't make it specific to Mercedes-Benz. I think Mercedes-Benz dealers are afraid of speaking out because they fear the repercussions, but it applies equally to all brands in Australia. We have seen dealers who have spoken out before, who have challenged manufacturers before, action has been taken against those people.
What do you mean by action has been taken, Mr. Vortman?
Yeah, so I have members who have questioned certain commercial arrangements before, initiated certain sort of proceedings against those manufacturers, and have been subsequently issued with non-renewal notices or termination notices.
So if you're so outraged by being ripped off by a big manufacturer that you say, look, this is wrong, we're going to go to court anyway, right? Make that decision, you decide to go to court, even if you have the money to do that, even if you have the time to do that, the manufacturer has power just to bring the whole thing to a close with the end of the next phase of your negotiation. So there really is there's no point in going to court.
No, well, I mean, look, the way this is the whole point, and where we're so different from the US is they have that requirement for termination with cause in the event of not only a traditional termination, but a non-renewal. I think Andy said expiration isn't good cause, expiration of an agreement. So what they've done over here is they've started offering shorter and shorter agreements. So every 5 years, they have the option to get rid of you if they like to. And that's what we've been seeing a lot recently, is these non-renewal notices. And the spectre of the non-renewal notice hangs over the dealer. So every time you ask to just accept a substandard warranty payment, every time you ask to report cars as sold when they're not, what's going through your head is, I better comply or I might be non-renewed.
In July this year, and this I think, given time, will be my last question, I might have someone notice for you, Mr. Vortman, but in July this year, Miss Seeger, who is Mercedes-Benz worldwide head of sales, warned that any changes to the Australian franchising laws of the kind that you've been asking this government to deliver would potentially crush its plans to move to an agency model. So pretty clearly, she said if the Australians get the laws in place in the way that the US has, Mercedes would not take on its dealership network and change its model. It would keep it, right? That's my understanding of what she said. Why would Ms Seeger warn against any changes to law that could protect Australian businesses when she already knows that Australian Mercedes-Benz dealers are not happy with the compensation offers that they are being provided?
Yeah, look, I did see those comments, and I think there were two elements to it. It was the compensation element, and the Mercedes dealers have told me that they have been told flat out, you will not be getting any compensation. If we had US-style laws, how Mercedes are going to move these guys from a traditional dealer onto an agency model is essentially letting the one-year agreement that they put all their dealers on expire and not renew them, and then offer the opportunity to become an agency. Under the US model, you wouldn't be able to do that. That would sort of fall foul of the termination without just clause prohibitions. And then under these principles, hopefully they'd need to pay the compensation that the dealers who have represented their brands for generation deserve.
Well, given the fact that you've got 50 flavours of legislation across the US to choose from, I hope that Minister Andrews and the government can actually do something for businesses across this country. Pick one, or pick the best bits of a few, and provide sufficient protection to small businesses across this country, particularly in regional and rural parts of Queensland, New South Wales, the Northern Territory, South Australia. Let's think about them this week. People need to be able to get their cars serviced, to buy in the area and actually have jobs in their local area.
If we had protections that were half as good as the US laws, we'd be in a much better space as an industry.
Like I said, there's 50 flavours. There's got to be one that they could get something from. Thank you.
Thank you, Senator O'Neill. That concludes your testimony today, so thank you very much. You are free to go.
Thank you.
You'll be sent a copy of the transcript of your evidence to correct any transcription errors. And I now call forward in representatives from